still like to go into the terminology and the academic background of the term communalism, because that is what translates into violation of minority rights when it comes to the law. And communalism is a term which is kind of well understood all over our South Asian countries. Sometimes misunderstood in the West, but it's increasingly getting understood. We are looking at a term which sort of evolved in the last 200 years, when we are talking about the manipulation of religion and religious symbols for political mobilization. So it's not communitarianism in the positive sense. When we use the word communalism, or we say Sampradayikta or Firkaparasti, we are looking at the misuse of religion or religious symbols for political ends. Not religion per se, but the misuse of the symbols for political mobilization. Now, it is the case, and it is our case, and it is our experience over the last 25 years working on the issue of communalism through Sabram Communications, through Communalism Combat, which is a monthly that was established in 1993, and through Citizens of Justice and Peace, an organization that was set up after the Gujarat genocidal carnage of 2002, that communal violence in its various manifestations has resulted in the acute deprivation of minority rights, which are guaranteed in theory in the Indian Constitution. So when we are talking about understanding this phenomenon that has defied the rule of law, defied the implementation of minority rights, we need to understand how communal mobilization itself takes place before we understand how we can combat it through the legal process. So therefore, it's important to understand what communal violence has happened. As we all who are part of, all of us sitting here in this room are part of South Asia, we know that convulsive events took place that led up to our freedom from colonial yoke and our throwing out the British. After years of struggle, there were very convulsive processes that took place, and the lead up to this entire process of seeking freedom from colonial powers was also marked at the same time by the emergence of certain ideologies which were not inclusive, which represented sectarian interests, represented their own interests, whether it was Hindu communalism, Muslim communalism, Sikh communalism, or Christian communalism. So that we are not getting into. But once we are getting into, once the nation state gets formed on the Indian side, we give ourselves within India a constitution. A constitution was given to ourselves on the 26th of January 1950. There's a huge deliberation. There's a deliberation of almost 18 to 26 months in the Constituent Assembly debates that go into the making of the Constitution. And the section of minority rights is very interesting. It's very interesting because there are essentially Article 14, Article 21, Article 25 in the Indian Constitution that guarantee right to life, right to equality before the law, right to freedom of religion, which freedom of religion inherently includes the right to propagate, express, and even convert other people to your faith, because Article 25 guarantees that right. Now, in addition to these rights which are there in the constitutional framework, we also have something called the Directive Principles of State Policy under Article 46 and 41, which had enabled from day one certain affirmative action possibilities which come under Article 15 and 16, which was a recognition of the fact that because Indian society had a very, very discriminatory caste structure, discriminatory economic imbalance, state could take affirmative action to right that imbalance, which was guaranteed under Article 15 and 16. Now, in the definition of those socio-economic categories of people for whom or in whose interest the state could undertake such affirmative action, you have definition of backward castes and backward communities. During the Constituent Assembly debates, and I've done some research on this because in the context of the Sector Committee Report, in the context of now we're having a new commission for Adivasis, also looking at the disparity in terms of delivery by the system against different groups of Indians, the debate in the Constituent Assembly on Article 15 and 16, what I call the legislative history of Article 15 and 16 is very interesting. Before partition happened, before we had the division of the subcontinent, before we had Pakistan being created, there was a certain understanding in the Constituent Assembly debates that Article 15 and 16 would include religious minorities. And then you had, for a variety of reasons that which we are not going into today, you had partition taking place, and then a resumption of the Constituent Assembly debates, then a draft constitution being prepared, which was accepted. Now, once partition had taken place, there was a certain defensiveness in the Muslim minority leadership within India to insist and press for the inclusion of religious minorities in the socio-economic backward category. So you had a committee under Sardar Patel which was debating this issue. And the only member from the minority who took it up vociferously was ironically Frank Anthony, a Christian, who insisted that you should include, as was originally intended, religious minorities, because it was found that in the Indian context, because of the history of conversions from the subaltern castes to Islam and Christianity, in the belief that Islam and Christianity would free them from the burden of caste Hinduism, a lot of the people who come under the category of socio-economic backward caste also happen to be religious minorities. That understanding was there. However, there was a certain climate, and unfortunately the legislative history of 15 and 16 articles did not specifically include the term religious minorities. Some of you might know, but many of you are quite young, so I don't know if you know. But in the entire period that India has seen very aggressive majoritarian communal mobilization, particularly since 1986, with the demand, ostensible demand, because the peripheral ostensible demand is the construction of a Ram temple at Ayodhya, whereas that was not the real demand. The real demand was to legitimize a majoritarian consciousness in politics within the framework of democracy. And this is what we are battling today. This is one of the most dangerous phenomena in India today. That you have democracy, the best system we know, you have elections, which we must have, but within that a certain majoritarian consciousness has come in, within the strata of governance, between the structures of governance, within structures of state, and of course within non-state actors and society as well. So when this movement for ostensibly for the construction of a Ram temple at Ayodhya was growing, which in effect was a majoritarian movement to kind of impinge a very majoritarian upper caste Hindu consciousness on the entire Indian polity, including systems of governance, the whole question of why this mobilization was needed was felt because of the Mandal agitation. I don't know how many of you are aware of that. That the entire movement by the other backward castes, which are called OBCs, to say that okay, you had 25% of reservations in political structures for the scheduled castes and scheduled tribes, which has been there since the beginning and has been extended periodically, recognizing that there's been years of discrimination, etc. But what about the OBCs who are also similarly discriminated? And the famous judgment of the Supreme Court, Indira Sani, was based on the Article 15 and Article 16 assurances that Constitution gave the OBCs. Now this is the background. Religious minorities were left out of it. So since the 1950s, we have a situation in India, for instance, where Dalit, those who are Dalits who happen to have been born within the Hindu paradigm, get benefit through certain reservations and policies. Through a constitution, through a cabinet resolution of 1953, 6, the Sardars, who are also should not really have a caste system, but who have it because caste has long overshadowed religion in India, are also given the benefit. So Dalit Sikh boys and girls also have the benefit of a certain affirmative action, but Dalit Christians and Dalit Muslims and OBC Muslims were kept out of the paradigm. So even now we have a huge litigation pending in the Supreme Court of India where Dalit Christians and Dalit Muslims are demanding that they should also have access to the same affirmative action and should not be discriminated against on the basis of religion. So this is the complexity of the issue. One of the greatest manifestations of discrimination in Indian society vis-a-vis religious minorities, because that's my mandate, I'm talking about minority rights here, has been through a denial of socio-economic rights, which are now sought to be corrected by a lot of affirmative actions of the central and state governments. Before I move on to the threat to life and property, which is going to be a major part of my presentation, Article 14 and Article 21, I'd like to mention that in 2005, the first UPA government set up a Sachar committee under Justice Rajinder Sachar, a former High Court judge of Delhi, and eminent academics, and gave the committee a year or 6 months to a year to look at the socio-economic condition of India's largest religious minority, the Muslim community. Now, strangely enough, Sachar did everything, a very good job. He actually, his committee reaffirmed what many of us working in the area already knew, but he collated all this information together to put a very frightening scenario before us, which by 2006 was very clear that 59 or 60 years into independence, and instead of getting slowly better, the socio-economic condition of India's Muslim community, particularly 60% of the lower caste Muslim community, had become steadily worse, both in rural India and in urban India. The variables were looked at. The variables were often compared to the relative improvement even of scheduled castes and scheduled tribes. I mean, I don't like to use words as scheduled castes and scheduled tribes, but it's a legal term, so I have to use it. I prefer to use the term Adivasis and Dalits. But our Dalit brothers and sisters' situation marginally, thanks to some affirmative action, had improved. But compared to that, our Muslim brothers and sisters had not. There was a national acknowledgement of that through the Sachar Committee Report. But one thing the Sachar Committee Report did not look at, conspicuously did not look at, were two things. One, the issue of Article 14 and 21, that is security. The whole issue of life and security was studiously avoided by Sachar. Question mark why? I have some ideas as to why it was avoided. And the second very crucial area which was avoided, which should interest all of us in this room, but particularly the women, is minority women who, according to many of us, face three levels of discrimination. Because they face discrimination through the discrimination of class, because they belong to a category of Indians who are discriminated by the thing, because we recognize that Muslims are discriminated against. They are also discriminated